RR Legal Talks. We will discuss on reverse insolvency. It's a new topic. How profitable companies revive bankrupt firms. We will talk about legal provisions and case studies. Reverse insolvency. In fact, some of the biggest businesses have turned insolvency into an opportunity. This is an opportunity for big business companies. This is what we call reverse insolvency, where a profitable company acquires or revives an insolvent business. But why should a company take over a sinking ship? Let's find out. Reverse insolvency is when a financially healthy company takes over an insolvent or financially distressed company to restructure and revive it. Unlike traditional insolvency where a company struggles to survive, in reverse insolvency, a stronger company steps in and takes control. Example, Tata Steel acquiring a Bhushan Steel in India. Another example, Reliance Industries acquiring future retail assets to strengthen its retail presence. Why does a reverse insolvency happen? It is due to business and strategic reasons. Acquiring a valuable asset at a lower price, this is an advantage. Expanding market presence, this is another advantage. Tax benefits, another advantage. I will explain one by one. Acquiring valuable asset at lower price. A distressed company may own plants, land, and intellectual property rights that the acquiring company can use that. Expanding market presence by taking over a company can enter new markets or eliminate competitors. Another advantage, tax benefits. Companies can adjust these losses of the acquired firm against their profits to save on taxes. This is biggest advantage. Retaining employees and skilled workforce. This is other advantage. Instead of shutdown, the workforce is absorbed. Preventing supply chain distribution. A company may save a critical supplier or distributor from collapsing due to delay of payments and debts, huge debts. And legal framework. Insolvency Bankruptcy Code 2016 and key legal provisions governing a reverse insolvency. Now we will discuss about IBC 2016. Section 5, subsection 26 defines a resolution plan where a solvent company can submit a revival proposal for bankrupt firm. Another section, section 29A, restricts promoters of bankrupt company from bidding for their own firm. And this makes a space for external solvent companies to take over distressed business. There is a section 12A allows withdrawal of insolvency proceedings if the creditors of the NCLT approves. National Company Law Tribunal plays a crucial role. COC plays a crucial role in approving or rejecting the acquisition of insolvent companies. Honorable NCLT plays a crucial role. Competition Commission of India, it ensures acquisitions do not create monopolies. So the real life example, we will discuss 3 examples. First, Tata Steel acquiring Bhushan Steel. Bhushan Steel had 57,000 crores debt. Under IBC, Tata Steel submitted a revival bid and acquired it for 35,200 crores. This move helped Tata Steel expand its production and market share. Another example, Reliance Retail acquiring a future retail assets. Future retail faced a huge financial distress and Amazon's legal battle complicated the matter. Reliance took over store lease ensure job retention, safeguard retail supply chains. These are all advantage. And we discuss another example. ArcelorMittal acquiring SR Steel. SR Steel had a 54,547 crore debt. ArcelorMittal, a global steel giant, bid under IBC and took over, strengthening its Indian presence. Of course, there are challenges. Reverse insolvency, it is not always a smooth. Here, some are challenges, regulatory approvals, because NCLT has to approve. Then, as per applicability, Competition Commission of India has to approve, and lenders' approvals required. And there is a debt burden. The acquiring company inherit liabilities and must restructure them. Legal disputes, example, Amazon versus Future Retail case, delayed Reliance acquisition. There is integration issues, employees, system, and branding need seamless merging. So these are challenges. So now the conclusion is reverse insolvency is a win-win strategy where a distressed business gets a lifeline and the acquiring company gets assets and market share. However, if it requires careful financial planning and legal compliance and proper advising and strategic execution. And would you interest in failing company to turn it around? Drop your thoughts in the comments. Like, share, and subscribe for more insightful business and legal breakdowns. Thank you. Subscribe to RR Legal Talks.